Good morning. Today I am going to discuss about the topic seizure, recovery and burden of proof. Onus. See, the investigating officer has got power under section 102 CRPC to seize certain property. Any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion of commission of any offence. Such police officer, if subordinate to the officer in charge of the police, shall forthwith report to the seizure to that officer. Then every police acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction where the properties was. This is what seizure. Then how to search all these things are there. So that was seizure. And apart from that, during investigation, the police officer may proceed or investigation and also conduct search, that is under 165 CRPC. Whenever an officer in charge of police station or making reasonable grounds for believing that anything necessary for the purpose of investigation into any offence which is authorized may be found in any place within limitation, he is in charge that recording the grounds for his belief and search that things. So you can search the person, you can search the place and seize it. So the question arises, what is seizure and what is recovery? That is most vital aspect you should understand unless and until you understand the difference between seizure and recovery. This for seizure, they may prepare seizure memo or form 95 and produce before the court. But for recovery, that is under Indian Evidence Act. Indian Evidence Act says the confession to the police officer is inadmissible. But however, after confession, if the accused taking you or giving information, which information may leading to recovery. So, prima facie, there is two requirements for recovery. Number one, confession, which is not admissible, but recovery, leading to recovery. There should be time gap between the confession and leading to recovery. If suppose an accused, after murdering his wife or anybody, produces the weapon as well as body also to the police station, it is not leading to the recovery. He has to say, go to the police station, confess, then he must give information that he hidden the knife at particular place, or he knows the place where the body is. So that leading to recovery is admissible in evidence. See, Indian Evidence Act deals with admission, confession. Confession before the police officer is inadmissible. Confession by other officers, other persons, by inducement, misrepresentation, fraud is inadmissible. Same with the admission is pertaining to civil dispute, civil issues, and confession is pertaining to criminal issues. So that leading, how to distract the leading to recovery is, if suppose there is no time gap or there is no absolute information in the portion of the confession, the entire confession will not be marked. The area in which leading to recovery information was there, that is admissible. If that leading to information is not having some exact particulars from where the other thing is recovered, then you can dispute it. Apart from that, the place where the recovery was deducted is known to everybody and free access to anybody. So that may not be proper recovery, but it is admissible recovery that is subject to appreciation of the court. So this is what most important. This not only for murder cases, 379 robbery cases, and 306, 304B, so many cases leading to recoveries there. So kindly concentrate to understand what is recovery. Seizure means if any property is seized, even without assistance of any person, if or any accused is producing certain things, and that is seizure. But that is not leading to recovery. Leading to recovery means there should be a confession, and pursuant to the confession, some information about the recovery of some fact or thing. This is most important. Here I have a case. This is AR 2023, Supreme Court 2239, wherein several things was discussed by setting aside the acquittal case. So if you want to go through the entirety of judgment, you can understand how to cross-examine the witnesses as done in before the court, wherein High Court has considered to acquit. This is what the judgment says, and you see, finally, appeal and confirm the judgment High Court. So High Court has set aside the acquittal. So they have confirmed the case. Problem was number one, cause of death, that was proved by the medical. Number two, see, he was last seen with the company of the deceased. Therefore, it is his burden duty to prove as to what happened and why he is not responsible for the murder. Number three, recovery. Here they have recovered it. Unfortunately, regarding evidence of recovery, there was some assistance of interpreter, and somebody has translated Malayalam to Tamil, and it was written in Kannada. So they say that itself is not sufficient, that the confession was not voluntary. And the inference, that is that the pursuant to his voluntary statement, body of victim was recovered from composite pit, so, and also some jewels. This is what they say. Therefore, the case was finally ended on conviction. Now the question arises, the recovery should be particular place. If suppose confession statement, the accused states that I have pledged the jewels to some so and so, then the recovery from that particular jeweler is admissible. But he simply says, I have pledged it, and without any particular subsequently recovery may not be acceptable, sustainable. These things are depends upon your way of argument before the court. But sometimes what happens, the confession statement leading to recovery is being marked with the Mahajar witnesses, recovery witnesses. Suppose they are not, they turned hostile, so then what happened? That may not be marked. It's even the signature alone may be marked if the witnesses admits the signature, but they say I do not know what is written, they have simply obtained my signature. Then the investigating officer may mark it. Then you have to specifically put a suggestion that actually there was no such confession statement or leading to recovery. It was your tainted investigation or table investigation should be the suggestion. So otherwise, if you are not giving that suggestion, the court may not reject the evidence of IO insofar as that recovery portion is concerned. Almost Even if the entire witnesses stand hostile, it is your bounden duty to shake the evidence of investigating officer unless and until you put suggestion as to why he has filed this charge, final report against the accused without properly conducting investigation. Otherwise, the court may believe because they are paid from our exchequer, they are representative of state. Best wishes.